let me know, because are we ready to go? Great. Welcome to this session of the OJA webinar series. Glad to have you joining us today from wherever you are on the province. Hope it's as beautiful for you as it is here in downtown Toronto. As you know, we provide these webinars usually on a monthly basis for your education. This particular session is worth 90 minutes of substantive, so don't forget to go to the Law Society portal and make sure that you record that. Just as we always do, we like to have a little disclaimer. You know, we are lawyers in the room and across the province after all. And so what we want to do is make sure you know that we believe that everything is current as of to date, but as being a legal professional, you will want to do your own due diligence. But certainly the information you are going to receive today is going to be extremely helpful. I'm going to do a very quick introduction of today's session. We're going to be talking about commercial leasing, and we're really excited to have 4 people presenting today. Other than our AGM, this is the first time that we've actually done a panel discussion. So gentlemen, welcome. We started with Mr. Harvey Haber, who is, from what I know, understand, is the person you go to for commercial leasing to understand. And he wanted to bring his colleagues along with him in speaking with these 4 gentlemen. They've been doing this tag team show for about 25 years, so I think you're in for quite a treat today. Let me do just a very quick introduction, though. I'm going to let each one introduce themselves more when they speak. First, we have Harvey Haber, who is QC. He's a retired senior partner from Goldman, Sloan, Nash, and Haber, but is now in his glory years taking on a new role as a mediator. So congratulations on your new role. That's terrific. Next to him, we have Earl Boyko, who is a bailiff with Sterling Bailiffs. And he's going to be talking about distress. Next to him, we have Sheldon Diesenhaus, who is a partner with Dentons Canada, and he's going to be talking about unusual cases. And then finally, we have Stephen Posen, who is a partner with Minden Gross. And thank you very much to Minden Gross for providing this great boardroom for us today. And he's going to be speaking about landlord and tenant defaults. So you don't want to be listening to me anymore. So without anything further, I'm going to turn this over to Mr. Haber to get us started.
Thank you very much. My name is Harvey Haber. I am a Queen's Counsel. I am also a chartered mediator and a chartered arbitrator, and I am the author-editor of 15 books on commercial leasing. You're always supposed to start off with a bit of a story, so here is a transcript of an actual radio conversation of a U.S. naval ship with Canadian authorities off the coast of Newfoundland in October 1995. Americans, please divert your course 15 degrees to the north to avoid a collision. Canadians, recommend you divert your course 15 degrees to the south to avoid a collision. Americans, this is the captain of a U.S. Navy ship. I say again, divert your course. Canadians, no. I say again, divert your course. Americans, this is the aircraft carrier USS Missouri. We are a large warship of the U.S. Navy. Divert your course now. Canadians, this is a lighthouse. Your call. What I've done basically is I've put together a series of questions, which I hope you all have by now. I'll renew the questions and hopefully try and give you some answers. Okay, what's the difference between usable and rentable? A lot. Basically, usable is the space that the tenant leases. Usually it's determined from the outside of the store to the middle wall adjoining another tenant, from the subfloor to the subceiling. It's the actual used area. There is a difference, though, with the rentable area. Most landlords, if not all landlords, in a retail commercial lease will add a portion of the common areas, a portion of the hallways, a portion of the parking lot. They're called common areas, and they add it to the usable or rentable area. Why would they do that? because basically the retail tenant pays rent on the rentable area. Let me give you a quick example. A kiosk might be 100 square feet in diameter, but the people who walk around the kiosk, the landlord considers that to be a common area. So they add that on as a rentable area. Therefore, the 100 square feet that's usual for a kiosk could end up being 130, 135 square feet, and the tenant pays rent on that rentable area. Is a renewal of lease and an extension of lease the same thing? No way. Well, let's presume it's a 5-year term with an option to renew or an option to extend. If it's a renewal at the end of the 5 years, there's a split second when the renewal term, the original term ends and the renewal starts. In that particular second, all of the personal covenants fall away. And originally in my books, I considered only the tenants falling away. But I've discovered that the personal covenants in that split second fall away for both the landlord and the tenant. Let me give you an example. If the landlord has given the tenant a right to buy the building, that's a personal covenant, and that would fall away. Now, when would that count? Well, basically, in the 5 years, and particularly today's market, the landlord could see the value of its building tripling, quadrupling, and could say, you know what? I don't want to buy that. I don't want to accept that particular aspect of giving the tenant the right to buy the building. And that's what the landlord could do and probably end up in litigation. An extension of lease is just a continuation of everything that is in the lease. Okay, most leases for banks, usually they say they like the concept of same terms, covenants, and conditions, including all the personal covenants. Generally, I recommend that what you do is just avoid the term renewal and use the term extension. Is a guarantee of a lease and an indemnity of a lease the same thing? No, it's not. Basically, a guarantee is a secondary liability. What does that mean? Basically, let's presume that the landlord says to the tenant, I want a guarantor, okay? And the tenant gets a guarantor, but it turns out that the tenant is a shell company. There's nothing there. The tenant defaults. The landlord then has to exercise all of its rights under a guarantee against the shell company, which is a waste of money, and then and only then can go against the guarantor. And in indemnity, it's a primary liability. In the event of a default by the tenant, then what happens is the landlord can claim directly against the indemnitor. It's a change of a word, but a very important change of a word. Can a landlord terminate a lease for a breach of the lease other than rent? The answer is no and yes. All right, what do I mean by that? The landlord has to give a notice if it's not rent, a Section 19.2 notice under the Commercial Tenancies Act of a breach. Give the tenant the right to fix the breach, and if the tenant doesn't do that, then the landlord can exercise its right to terminate the lease. If a tenant is in default on the payment of rent, can a landlord seize the tenant's goods, chattels, and inventory? Usually I refer that to Earl, who will tell you anyway, but in any event, it's got to be rent. The landlord's got to seize and can only seize for rent. And it's against the tenant's goods, chattels, and inventory. And Earl will tell you more about it. Does it make a difference if a notice to renew or a notice of extension is late by 1 day? You bet. You bet. If it's United States, not necessarily. The U.S. courts are much more lenient. If a tenant gives a notice to renew or a notice to extend in the United States, the courts generally say, look, if it's not, there's no serious detriment to the tenant, then we'll go for it. Not in Canada. In Canada, it's considered a condition precedent. That notice has to be given on time, when due, and has to be given unequivocally. If a tenant has been in default and has cured the default, can the tenant then still exercise its right to renew or extend? The answer is yes. Yes, tenant's been in default, landlord's given notice, tenant has cured the default. If that's the case, the tenant can then exercise its right to renew or extend. There is an exception. If there are numerous defaults, then a landlord would argue that it has the right under those circumstances to terminate. Can a landlord withhold its consent to a requested assignment reasonably unreasonably or not at all? Well, reasonably is the usual provision in a lease where the tenant requests the right to assign or transfer its lease, and the wording then goes on that the landlord's consent will not be unreasonably withheld based on reasonable criteria. Okay, what if it says that the landlord instead can unreasonably withhold its consent? Our courts have said, yeah, they'll abide by that. If the landlord can establish that it's unreasonably withholding its consent, the court will uphold it. What if it says not at all? What if it says instead of giving any consent, I want to terminate the lease? The landlord says, I'm exercising my right to terminate. Okay, what happens then? Well, if the lease has said that the tenant can step back after receiving that notice of termination, then they will uphold that provision. But if it says that the tenant has no right to step back at all and withdraw its request, then the court says, sorry, we're not going to uphold that clause. Can a landlord withhold, let's see, 3 arbitrators? No way. Why not? Well, it costs a fortune, an absolute fortune if there are 3 arbitrators. The clause usually says that the tenant has the right to renew or extend on the same terms and conditions except for rent. And how is rent to be determined during that exercised renewal option or extension option? To be determined by arbitration. Well, arbitration in the old days was a choice of 3 arbitrators. Tenant picked 1 arbitrator, landlord picked another arbitrator, and the 2 picked a chair. There were 3 arbitrators, okay? However, those 3 arbitrators, based on their fee, would be about $500 each an hour, okay? Then there are 2 appraisers. Let's say they're $500 an hour each. Then there are other contingencies as well. Lawyers involved, about $500 each, okay? So if you're talking an amount that's not a lot of money in dispute, okay, then what you should do under the circumstances is appoint a single arbitrator that the parties agree upon who is experienced in that particular matter. Otherwise, you could end up with a fee before you open the door to the arbitration of $25,000 to $30,000. What's the difference between a mandatory mediation and an arbitration? A lot. Okay, mandatory is determined by the court. The parties don't agree on a mediator, and what the court says, okay, we'll designate a mediator. What the mediator has is an opportunity to try and settle the mediation. It has no power at all to coerce or force a mediation. What it does is it puts the parties together. It tries very hard to get them to settle. An arbitration, however, is like a court. The arbitrator has the same powers of a judge, but reduced. The rules and regulations with regard to an arbitration are lessened under the Arbitration Act of Ontario. Red line, black line. What's the difference? Again, a lot. The first draft of the lease has the premises lined in red. Okay? Second draft of the lease has the premises lined in red. The third draft of the lease, the parties are negotiating the lease. There's no premises lined in red. Nobody knows where the premises are. What do you do under the circumstances? You hatch the premises in black. You can run 7 million copies of a premises that are hatched in black, and they're still hatched in black. Okay? Lessee and lessor. What's the difference? A lot. Don't use lessee and lessor. Why not? It's too easy to make a mistake. You know, the landlord puts down that the lessor will pay the lessee's taxes. Okay, big problem. So what do? You don't use lessee or lessor. You use landlord and tenant. If you're going to misspell it, it still looks like landlord and tenant. Next, check the tenant's insurance certificate. Why? Because they're always wrong. They're always wrong. What you got to do is you got to get the tenant certificate in, you give it to your insurer, and you discover that all of the items that you want covered $5 million, public liability, property damage, they're not covered properly. So what you got to do is you got to be very careful, send it back, and have it done properly. Why is an architect's certificate important to both landlord and tenant? Because everybody argues over the rentable area of the premises. Everybody. Landlords, tenants, architects, everybody. What you do is what I've always recommended is that the landlord obtain the services of an independent architect, do an architect certificate as to the rentable area and the rented area, and let them form part of the lease. Okay, that avoids litigation, that avoids contention, and that avoids aggravation, I can tell you. Why is an audited statement of operating costs important to both the landlord and the tenant? Because everybody fights over operating costs. So what you do is, again, the same thing. You have an independent auditor prepare the costs of the occupancy costs and present them to both parties. You'll find that reduces litigation, it reduces aggravation, and it helps. Why is the definition of rent important? Because as you will tell me, everything in the lease should be that is payable by a tenant should be rent. Why? Because basically what happens is the landlord wants to exercise its right of distress. Thank you very much. Thank you. I need that. Okay. So rent is important because the landlord wants the right to seize for outstanding rent. What's a pro rata share of operating costs? What happens generally if it's a pure pro rata share of operating costs? It's a fraction, the numerator of which is the rentable area of the premises, and the denominator is the rentable area of the development. Okay, that's a pure pro rata share, and that's what the tenant pays. Most leases are not a pure pro rata share. They are not. Basically, what happens is the numerator is okay, the rentable area of the premises, but the denominator is the rentable area of the development, except for numerous exclusions. Okay, the supermarket, the larger stores, the department stores, they're all excluded. The area is excluded, which means, of course, that the tenant pays more money for operating costs. Many tenants will say, well, how much is the supermarket paying? How much is the department store paying? Most landlords won't agree to giving those particular figures. Is there a difference between an offer to lease and an agreement to lease? Not really. Some say that an offer to lease, once it's signed, becomes an agreement to lease. Okay. Is an offer to lease really necessary? Well, in the United States, it's not. In the United States, basically, they say, look, you sign the lease, you get in. You don't sign the lease, you don't get in. In Canada, it's a little bit different. They still like the offer to lease. It's shorter. It's negotiable. Usually what happens is if the lease is attached, and legally it should be, if it is attached, it's usually about 50 typewritten pages. Okay, so a landlord would prefer to negotiate a much shorter document and take the risk of putting the tenant in after the offer is signed. Is percentage rent being phased out? It depends. If you're a larger tenant today, Shoppers Drug Mart, they don't pay percentage rent. Many of the department stores, they don't pay percentage rent. Some of the smaller tenants pay percentage rent. Why and how is notice to be given? This is notice to be given by a tenant. A tenant has to give notice in accordance with the lease. If the lease says it has to be delivered by dog sled, you got to deliver it by dog sled. If it says registered mail, fax, email, whatever it says, that's what the tenant does. There's a situation where the tenant's lawyer sent notice to the landlord's lawyer, phoned up the landlord's lawyer and said, I sent you the notice of exercise of the option. Did you get it? The landlord's lawyer says, yes, I got it. And he says, the other side says, good. And the landlord's lawyer then says, it's invalid. And the lawyer for the tenant says, what do you mean it's invalid? He says, was received 1 day late. Okay? 1 day late makes it invalid, at least here in the position that we're taking, that is a condition precedent. So be careful as to how notice is to be given. And last but not least, is a non-disturbance agreement important for a tenant? You bet. What is a non-disturbance agreement? Well, basically what happens is the landlord usually obtains a mortgage from its mortgagee. Okay? And what happens if the landlord falls into default under that mortgage? Well, the tenant says, look, Mr. Landlord, before I enter into any lease, I want a non-disturbance agreement from the mortgagee. I want an agreement between myself and the mortgagee that if I fall into default, then the mortgagee is going to honor my lease so long as I'm not in default. Anyway, that's it for me. Thank you so much.
So I'm just going to ask Edward right now if we have any questions.
Nothing yet.
Okay, so we don't have any questions at the moment, but please feel free to definitely type your questions. If you put who your question is for, then we can make sure that if it's not answered during the presentation, we'll get them answered afterward. Edward Sullivan, who many of you met at the AGM, is monitoring for us today. So we'll make sure your questions get answered. So at this point, I'm going to turn the mic and the camera over to Earl Boyko.
Thank you. Welcome, ladies and gentlemen. My name is Earl Boyko. I'm a bailiff. I was appointed under the Bailiffs Act. In those days, it was by order in council by the Lieutenant Governor of Ontario. Today, it's done by the ministry. I'm the owner of Sterling Bailiffs and also Universal Bailiff Services. Universal has been around for about 60 years. I'm here to talk about remedies available to commercial landlords in a default. And there are basically two remedies available. One is termination, the second is distress. Steve Posen will be talking later, we'll be talking more in depth. But typically when I get a call from a landlord or the solicitor, we discuss the two options, termination or distress. And I start asking a few questions. I look at what the landlord wants to accomplish, the current economic factors, how leasable is the space that we're acting on, what the arrears are, what type of tenant you have, what type of business. Different economic times warrant sometimes different actions. In good times, you may have other potential new tenants willing to take over the space at a greater rent, so you don't mind kicking out or terminating the lease. But in tough times, a landlord doesn't want to have the space sitting empty, pay real estate commissions to get it in. So many times you'll see landlords say, well, whatever he's giving us, it helps pay some of the taxes, some of the TMIs. So different economic times make it a large factor. Is notice required by a landlord? Check the lease, because the lease will call for notice to remedy if it's required. The governing rule is we like to give notice if you're terminating a lease. In a distress, again, check the lease. So what is a lease termination? Lease termination is basically we're going in, we're taking possession of the premises. And I know Steve will get into this in a minute. A termination could be on rent arrears or breach of other covenants. We're basically, when we go in, we retake possession of the premises. We're giving the tenant 5 days, remove the goods or pay up. But when you when you do a termination, you withdraw your rights to seize any of the assets of the goods and chattels inside. We use what's called a Kelly Douglas notice, which is a Supreme Court of Canada ruling that you have the right to sue for future obligations under the lease, but you still have to mitigate your damages. Distress, totally different ballgame. It's seizing of the goods and chattels of the tenant to satisfy rent arrears and additional rent arrears. And as Harvey said, I mean, realistically, it has to be defined. Any cost associated with what you're distraining for has to be defined as rent or rent arrear or additional rent. We're not terminating the lease. So the lease still remains in effect, and there must be a monetary default. If it's a non-monetary default, you can't distrain. However, you can convert a non-monetary default into a monetary default. For example, if the tenant is responsible for the roof, and the roof is leaking, and the landlord says to the tenant, fix the roof, it's under your obligation under the lease, and they don't. Well, the landlord can go ahead and fix the roof, bill the client, and if he pays the bill to fix the roof, it becomes a monetary default. Next, if you're going to use a bailiff, and I strongly suggest you use a bailiff for a landlord, then choose the right bailiff. First and foremost, check the jurisdiction of the bailiff. Bailiffs are appointed in a specific region. Our jurisdiction is the City of Toronto. However, the Bailiffs Act allows for what's called a Section 4 consent to act in other areas. In the old days, we had to have a judge sign this. Now it's done by the ministry themselves. And our firm holds blanket consent for the entire province. Most bailiffs are car repo guys. They lack the experience. The laws governing distress are a very gray area. We rely on case law, and we have a lot of conflicting case laws. So you've got to be very, very careful on what bailiffs a landlord uses. Priority over secured creditors. Well, a landlord does take priority over banks, finance companies, etc., especially on a GSA. However, they cannot seize items in a distress that are third-party items or leased items. PIMSY is a classic example. Theoretically, title to those goods do not belong to the tenant. So if it doesn't belong to the tenant, then you can't seize it. Other things, the property has to be on the goods that you're seizing has to be on the property of the landlord. So within the confines of the four walls, however, there could be a parking lot that belongs to the landlord. And if there's a company car, for example, the landlord has the right to seize that car as well, as long as it belongs to the tenant. When I get a file in from our clients, I look at paperwork and I ask them for a few things. I ask our landlords to provide us a copy of the lease, or at least the first and last page of the lease, because I want to get the proper spelling names of the landlord, the proper spelling names of the tenant, and I want to see what other guarantors or identifiers are on the lease. I look at things that for the notice that's required, should we act? And I ask for a full statement of account, what they owe, usually going back at least 6 months. I also ask our clients, don't wait till the last minute. Our busiest times are Friday afternoons, especially at the end of the month, when tenants are typically doing midnight moves, especially on long weekends. If you call me on a Friday, the last Friday of the month at 2 o'clock in the afternoon, our firm will not be able to handle it because we're too busy. We ask for a distress warrant or indemnification direction from the landlord. What this is exactly that. It's a direction from the landlord to seize the goods and chattels from the tenant. It defines exactly what's owed. It's our mandate to do it. So once we get all that information, we go ahead and proceed. There are basically two types of distresses. One is a constructive distress, or we have the right to remove goods. When we go in, probably 99% of the time, we don't actually remove the goods. We tag them, take an inventory of what's there. But when we enter the premises, there's a few rules that are on the books, if I can use that term. It must be peaceful. We cannot break in. It has to be done in daylight hours only. And that comes from an old case law that a judge ruled in the 20s that by moonlight, you couldn't tell the difference between a brown cow and a gray cow. Absolutely ridiculous in today's modern world, but theoretically, it's still there. You cannot use a key to enter the premises. So if you do any of those, it can be construed as an illegal distress right from the start. Okay, so we've gone in, we've asked for the owner, and we've served them with this distress warrant, and we've told them what we're doing. As I say, 99% of the time, we tag goods and take a video of the pictures of the items that we seize. We try beforehand to do a PPSA search to determine about those third-party goods, to see if there's any leases showing. They don't have to be there, especially on a true lease. But you ask questions. You ask the tenants, are any of these goods third parties? Are they consignment goods or whatever? And you try to seize enough to cover the value of what the rent arrears are. And this is where expertise comes into play, because there are a lot of equipment that we know in a distress situation, in a distress sale or a liquidation sale, that we're going to get pennies on the dollar. One of the busiest types of businesses that we have all the time are restaurants. Brand new restaurant equipment gets somewhere between 10 and 15 cents on the dollar. And this is in great shape. Most restaurants that we go into, the equipment is useless, it's old, and really has no commercial value whatsoever. Jewelry always has a value because you've got its melt value, especially with gold or precious metals or precious stones. So expertise allows us to determine what we should be seizing and how much we're going to be seizing. Why? Because we don't want to over the strain, because that could be a no-no. Many years ago, I did a file that the landlord sent us in and told us there was $33,000 worth of rent arrears. It was a retail store, and we seized approximately $150,000 worth of assets, retail value, because we knew we were going to get about 20 cents on the dollar. Well, the landlord made a mistake, and the tenant really only owed $3,300. Obviously, we overstrained. They took us to court. We settled out of court very quickly, but one has to be very, very cautious. All right, once we've seized items and we've left a copy of what we've seized with the tenant, we leave. And then there's a 5-day period. And in between that period, if the tenant feels that the landlord did it wrong, he can obviously put in an emergency motion with the courts, or alternatively get the lawyers involved and sit and go back and forth. But at the end of 5 days, the Act requires us, should we want to proceed and go to sale, the Act requires us to get 2 appraisals sworn under oath. And contrary to what most people believe, sworn under oath is required beforehand, not after they do the affidavit. After the appraisals are done, we have the right to start selling. And it's a key that we try to get the best available price for the assets. Obviously, you want to keep it arm's length. You don't want to sell it to the landlord. The landlord should not be buying assets that belong to the tenant, nor his brother-in-law or his wife or whoever it may be. And the key is that's the reason why you got the appraisals. You want to get the true value of what they're worth. Public auctions are a wonderful way to sell items, or inviting public bids of some sort, because, again, keeping it arm's length. All right, so now you've sold. You've got to disperse the proceeds. There are some priority creditors that come ahead of the landlord. We'll talk about Section 22 of the Retail Sales Tax Act, and this was put out before the merger of PST and GST to form HST. And the provincial government were geniuses in putting together Section 22 because it made every landlord in the province their tax collectors. What we are required to do is, before we disperse, we're required to see if they have a super lien over the landlord on the goods and chattels. Because if there are owed PSD portion or the HST today, I mean, they do come ahead of the landlord. So we send off under Section 22, and the provincial government sends us a clearance certificate and or a demand on how much we have to do. The same legally holds true with, of course, the federal part, the GST portion, and the employees portion of employee deductions. We have a problem, though, at times with dealing with CRA, because they come to us as a bailiff. I'll put in our requests if there's something owed, and they'll say to us, we can't talk to you for confidentiality purposes, even though you're in there and you're legally in possession of the goods and chattels. Go ahead and get the tenant to send us a letter authorizing us to talk to you. Well, that's ridiculous. I, as an ex-director of the Ontario Bailiffs Association, held many meetings with them and said, look, I mean, if you're super priority creditors, then you have to let us know, because we can't disperse without your okay. And if we do disperse, we certainly don't want you to come back after us or after our clients, the landlord, if you don't give us that information. They still to this day don't give us that information. It's very hard and difficult dealing with them. However, on the PSD portion of the Section 22, the province is letting us know how much is owed on the HST in total. Throughout all of this, we look at it has to be peaceful, and that is the key, that it has to be peaceful. We often at times call the police to assist us. In most cases, the police are very reluctant to assist us. They want to, even if we ask them just to be there to keep the peace, they'll say it's a civil matter, and they'll ask us to either leave and come back with a court order, or alternatively, I mean, if we're lucky, we'll get the right police officer who will indeed help us, or the sergeant. All right, once you've sold and you've completed your distress, is the lease still in effect? Yes, you haven't terminated the lease. Is there sufficient? Was there sufficient proceeds from the distress to satisfy the full arrears? Well, if there was, then the lease theoretically is in good standing. There may be 4 walls left in the place with absolutely no merchandise, but it is still in good standing, so the lease is still legally in effect. If there's a shortfall, can you terminate? Yes, you can. However, we have some interesting case law. I don't know if Sheldon's going to get into this here, but new case law says, well, if there is a shortfall, you can't just terminate. You've got to re-give notice again. So one has to be very careful about that as well. How much time do I have? A few minutes. About 5 more minutes. Well, are there any questions?
We do have one question online, which I think is for all of you. Does the Small Claims Court have jurisdiction to deal with claims made after the termination of tenancy? There seems to be some dispute in different counties on this.
Can I just ask clarification of the question, or you can't give it? Because when you say jurisdiction, you deal with amounts after the termination of the lease?
Yes.
Are there still amounts owing? Sorry.
I will ask her.
If there are amounts owing by the tenant to the landlord after the termination of the lease, yes, the Small Claims Court does have jurisdiction to adjudicate on that, subject to the Limitations Act.
Okay.
So if I still have 2 more minutes, just one cute story that a number of years ago, and those people who are familiar with downtown Toronto will know what the Path is. The Path is the underground area that connects all the different buildings one to another without having to go outside. And there are a lot of retail stores. So we acted, and I was there myself, I acted on behalf of a very large commercial landlord. And it was a clothing store. And we decided that we were going to remove items. The landlord had a vacant store 2 doors down. And so, and the tenant had racks on wheels in the place. So we decided we were going to take these racks, fill them up, and move it into the premises that were 2 doors down, and we can lock them up and secure the premises, which we did. So the tenant is frantically on the phone trying to connect with his lawyer, and he said to me, "My lawyer wants to talk to you." Well, I said, "Lucky me. I mean, probably another one, a member of your profession, threatening me with a lawsuit." And of course, my usual answer is spell my name right. And I pick up the phone and I go, "Yes, this is the bailiff." And the voice on the other line says, "This is Harvey Haber. You know who I am?" Now, Harvey and I, of course, have been friends, and we've been doing this lecture for 25 years. And so I respond to him and I said, "Yes, Harvey, I know who you are, and this is Earl Boyko." He goes, "Earl, of all the bailiffs in town, I have to get you." He says, "Can I challenge your distress in any way?" I just shook my head and I said, "Harvey, here's the name of the landlord. Call them up, do a deal." And they did, and we resolved it. But it was just a very cute story. Thank you.
Well, thank you very much. Really appreciate that, Mr. Boyko. That was a good story. So at this point, I'm going to turn the microphone and the camera over to Sheldon Diesenhaus. Coesetus Judges, and he's going to talk to you about unusual cases in this area.
Thanks very much. So I had a little concern as to what I was going to say about cases to a group of judges. Often I speak about cases and I try to explain to lay people how these cases are decided, how judges look at matters in different ways, and how, in fact, different levels of courts, often look at matters differently. So what I've decided to do is go through some of the cases that I often refer to, some that I thought, not the leading cases. So I'm not going to talk about Kelly Douglas. I'm not going to talk about Crystalline or Goodyear, the major cases or that we deal with when we talk about leasing. But some other cases which I've found, or quite frankly, my associates or students over the years working with me have found, very honest, and that I thought might be of some interest. I'm not going to provide the sites for all the cases as we go through, but certainly if there are any cases that anyone wants to look at specifically, either ask through the questions or you can get a question through to me afterwards, and I'd be happy to send you the actual site. So the first case I thought I would touch on deals with indemnifiers and leases, and a discharge of an indemnifier due to the actions that the landlord might take. This case happens to come from BC. There are quirky things about a lot of these cases, and they come from BC, and that's just the nature of the BC courts. Maybe I shouldn't say that in front of judges, but that's what we all say.
If you don't, I will.
Okay. So in this case, the lower court held that a landlord had fundamentally breached the lease when it unreasonably withheld its consent to a sublease. And that as a result of doing that, the risk to the indemnifier was greatly increased, and therefore entitled the indemnifier to be discharged. So in this particular case, the subtenant or the tenant had requested the landlord's consent on 5 different occasions to consent to a sublease of part of the premises, and the landlord never asked for information. The landlord never indicated that it would consider the subtenant undesirable, just ignored the request. So the landlord was found to have dramatically increased the risk to the indemnifier. So this is the guarantor / indemnifier. We won't worry for these purposes about the technical differences. And that case actually was appealed to the Court of Appeal in BC, which agreed with the lower court and decided that as a result, the indemnifier was discharged of its obligations. A case dealing with lease interpretation. In this case, the court was looking at a lease which said that the tenant would provide, or tenant would pay for, amongst other things, quote, the cost of general maintenance and repairs to the plant and equipment supplying climate control. And the landlord was responsible for structural defects to the building. There was an inspection of the furnaces, and it was determined that the landlord had to replace the 3 furnaces. The furnaces were replaced, but the landlord then sought to recover that amount from the tenant. So again, keeping in mind what I indicated were the tenant's responsibilities, what were the landlord's responsibilities. So the trial court looked primarily at the landlord's obligation to deal with structural repairs and held, in that case, that all constituent parts of a commercial building, excluding decoration and ornamentation, were the responsibility of the landlord because the landlord was responsible for structure. And as a result, the trial court held that the replacement of the furnaces was the responsibility of the landlord. That's what it is.
No, I'm asking. I'm just looking for the court.
Saskatchewan. Okay, so I mentioned this case because that would seem rather odd, and had I asked the question, I think of my co-panelists and probably most of you, you would say, the furnaces aren't structure, but the lower court actually found that it was. This matter was appealed, and the Court of Appeal reversed the decision. Perhaps not surprising. A case from Ontario, which when it came out caused a lot of consternation for many of us, but which has resulted in us, those of us who practice in this area, changing some of our drafting, was a case that dealt with Nortel. And this was a situation where Nortel had a right of early cancellation. So in its lease, it had a right to cancel the lease on payment of a certain amount. That's not unusual, but the lease or Nortel had this right provided that the tenant, so being Nortel, or a subsidiary is in occupancy. And the point here is, what does in occupancy mean? So at the time that Nortel sent its notice to terminate the lease, it in fact had no employees working in the leased premises because they'd all been transferred to other facilities. So the landlord's position was the cancellation clause required the tenant to be in occupancy. It wasn't, and consequently, there was the right to terminate would not apply. Nortel's position, and I'm not sure who the lawyer was, but I think at the time this actually was quite novel. Their position was that there's no reason to suggest that the term in occupancy requires physical occupation, because they were in legal occupation because they had executed the lease. And the court considered a variety of definitions of occupancy, looked at a number of dictionaries, and determined that the usual definition includes legal occupation by way of tenancy or otherwise, as well as physical occupancy. And court held that there was no reason to restrict the definition to physical occupancy only, and as a result, determined that notwithstanding that it had no employees there, Nortel was in occupancy for the purposes of that termination. So as a result, when we draft these clauses similar to this, or other rights that are very specific to the tenant, we are often requiring the tenants to be in actual physical occupancy. And so the point simply is that the drafting there has resulted in, or this case has resulted in all of us being more precise in our drafting. Another case, which is from the Ontario courts, deals with what the word effective means. So this lease provided as follows. The lessee, Harvey, it said lessee, shall have the right to terminate the lease effective May 31, 2004, upon delivering to the landlord at least 6 months prior written notice, together with a penalty equal to 3 months' rent. Okay, so the key here is the right was to terminate the lease effective May 31, 2004. So the tenant served a notice of termination to be effective on November 30th, 2005, and the landlord objected. And the landlord said the termination right was a one-time right only, that if it was to be exercised, would terminate the lease on May 31, 2004. The tenant took the position that it had the right to terminate the lease at any time after May 30, 2004, as long as the notice and payment conditions were satisfied. So again, going back, the lease provided the tenant has the right to terminate the lease effective May 31, 2004. So the landlord actually submitted an application to the court for interpretation, and the court found in favor of the tenant's position, which was that the right became operative on May 31, 2004 and continued throughout the remainder of the term of the lease. So again, this was the word effective, and the court held it meant to mean coming into operation. And it could have been understood differently, but that is the way the court decided. And when I speak to lay people, you make the point about how important drafting is, and you really have to think through how a clause can be interpreted, and as a result, make sure that your drafting is clarified. Determining the relevant time for examining intent. If as a court you're looking at the issue of intent. In this particular case, the parties were looking at a use clause. And the clause stated as follows. The demised premises may be used by the tenant for the purpose of grocery store with ancillary parking lot and other retail uses, and for no other purposes whatsoever. And the question was, what did this mean? Again, grocery store, it's pretty clear, with ancillary parking lot and other retail uses. The landlord wanted to make the point that the lease did not permit the use of the premises for businesses other than a grocery store and other resale uses which are ancillary. But the lease didn't say ancillary retail uses. It said retail uses, no other purpose purpose of a grocery store, ancillary parking lot, and other retail uses. There was no comma. So did ancillary mean just an ancillary parking lot or ancillary retail uses? And at the end of the day, the court found that when the tenant entered into this lease, it was fully aware of the landlord's position. And the landlord's position was that it was to be a grocery store and that other retail uses referred only to uses that are ancillary or supportive of the primary grocery store use. And again, it's an issue of drafting as clearly as possible. Okay. Late payments of rent and exercising the right to renew. Again, something that Harvey touched on. Here the lease read as follows. The tenant, actually, it said lessee. It was an old lease. The tenant, having at all times faithfully performed all of the terms and conditions of this lease and not being in default, shall have the option to renew this lease under the same terms and conditions. So the landlord's position was that the tenant had lost its right to exercise this option to renew because it didn't pay rent at all times when it was due. And the tenant often paid as late as the 30th of the month. The tenant sought to exercise the option to renew because at the time it was not in arrears. But the landlord was hanging its hat, so to speak, on the wording that provided that the tenant must have faithfully performed all the terms and conditions of the lease. And in this case, the court found in favor of the tenant, in favor of the landlord, and took the position that faithfully really meant constantly. And based on the record of late payments, the tenant did not constantly perform the conditions of the lease. Another case dealing with right of renewal. Again, this is a BC case. The renewal clause here provided that if certain conditions were satisfied, the tenant would pay rent during the renewal term at a rate equal to the then fair market rent for renewal tenants in the building. The letter stated in part, but from the tenant, the letter exercising the right to renew stated that we hereby tender notice of our intention to exercise the option to renew, subject to satisfactory negotiation of the lease terms. So there were two problems with this. And interesting in this case, it was the landlord that wanted to establish that there was a renewal, and it was the tenant who was backing away from the language of its exercise of the renewal. But the problems were that this wording was not clear and unambiguous. It said, we hereby tender notice of our intention to exercise. It doesn't say we are exercising. It also refers to satisfactory negotiations of the lease terms. So it wasn't unambiguous. It wasn't unequivocal. It was conditional. So if you want in the negotiation of the renewal to raise other issues, you shouldn't say it in your notice. And perhaps you might be able to deal with them later. Another case dealing with renewals, again, this one's from BC. Tenants send a letter purporting to be an exercise of the renewal, and what they said was, in accordance with the renewal option set out in the lease renewal dated whatever date it was, we're writing to formally exercise our 5-year option to renew the lease, and included the dates. But again, the letter went on to talk about other issues, talked about different definition of permitted uses. And again, the court made the point, and this is sort of the bottom line point, the exercise of the renewal must be unequivocal and unambiguous. How am I doing for time? Okay. Okay. Another case dealing with what the tenant's business is. The use provision in this lease allowed the tenant to operate a fast food restaurant, as well as to use a minor portion of the premises for offices as reasonably required for the tenant's business and for no other purpose. So again, it was a fast food restaurant. This I happen to know about this because, well, it wasn't my matter. This was a case that was in our office. The plaza happened to be near a university. This was a restaurant, and it was obviously catering a lot to university students, many of whom do not carry around credit cards or do not carry around a lot of cash. So the landlord, or the tenant rather, the restaurant operator installed an ATM machine on the premises, and the landlord was not happy. This was not a situation where there was a bank that had an exclusive and that there couldn't be other ATMs, although that raises a separate issue in this case. But the point is that the landlord wanted the ATM out, said it's not covered by the permitted use clause, which it wasn't on the face of it, and the landlord went to court. And they said because non-customers of the tenant could access the ATM, which was just in the foyer of this restaurant, the tenant was offering banking services in violation of its lease. The tenant took the position that the lease implicitly required an ATM service to be used so that the tenants, so that the customers would have access to money and to pay, and the lease also provided that the operation of the business would be in such a manner that would, quote, produce the maximum volume of sales from the premises consistent with good business practices, which is also wording we often see in leases. So interestingly, to many of us, the court in that case held that the use of the ATM was for an appropriate business purpose, and that unlike a bank, the ATM, in this case, the ATM did not accept deposits. It was just there to dispense funds. And because banks are regulated by the Bank Act, which was not the case here. So the court found the ATM did not change the use of the premises in any way, and it was used for, as I said before, appropriate business purposes to assist the tenant in keeping his costs low and his clients happy. And the landlord's application was dismissed, and the landlord appealed, and the landlord lost on appeal. So that raises a number of issues. You have to be very careful in drafting, because if in fact there was a bank that had a restriction on the use of ATMs in that plaza, and the landlord wasn't, in the drafting of his lease, he didn't deal specifically with the exclusives, and that wasn't registered on title, the court decided that this fell within the provisions of the use clause. Okay, I'm not going to speak about realty taxes. Relief from forfeiture. This was a case in Ontario. Oh, no, went to the Supreme Court. Supreme Court of Canada, refused to hear this decision. Leon's Furniture, which many of us will be aware of, entered into a 30-year lease with options to renew. The lease required the tenant to obtain consent to an assignment of the lease, which is pretty standard. Leon's had sublet a portion of the premises, and then the landlord consented to the subtenant leasing additional premises. So there was an issue of a renewal of the sublease for an additional 5 years. The tenant renewed its lease, but didn't inform the landlord that it would continue to subleasing the premises to the subtenant. So remember, there's a number of layers here. So the landlord sent the tenant a notice of default, providing that it was in breach of the lease because it didn't obtain the landlord's consent to the continued sublease. And the lower court dismissed the landlord's application and held that a fresh consent was not required because the landlord had already consented to a sublease. And the Ontario Court of Appeal actually allowed the landlord's appeal and held that the earlier consents could not be regarded as consent. So there were a lot of considerations in that case because the tenant also applied for relief from forfeiture based on the let me take a step back. The Commercial Tenancies Act does not permit relief from forfeiture or does not provide for relief from forfeiture when you don't obtain consent to an assignment or a sublease. But there's the Courts of Justice Act, Section 98, which provides for equitable relief. And in this case, the court decided that there wasn't enough evidence on the record to determine whether equitable relief should be granted. But they ordered a trial on this issue. So the point simply is that the Courts of Justice Act could become relevant in that kind of scenario. One or two other cases. A lease provided as follows, again, Ontario Superior Court decision. Any such renewal to be on the same terms and conditions as are contained in this lease, except the form of the renewal lease shall be at the landlord's option, a lease extension agreement, or a new lease in the landlord's then current form. So as a tenant, you're faced with, when you're negotiating this kind of renewal provision, presumably you want to say that there'll be a renewal agreement, but it's the same terms and conditions and not the landlord's new, then current standard form. In this case, the Superior Court required the tenant to enter into a new lease on the landlord's then standard form, which certainly could result in many changes in the terms of the lease. There is a difference between a security deposit and prepaid rent, and there's some fairly recent case law on this. And a non-refundable deposit to be applied to rental payments or defaults of the tenant was considered prepaid rent. And it was the issue becomes whether the prepaid rent is a security deposit, which in a bankruptcy there becomes an issue as to whether it is. There was a registration under the PPSA and what the priorities might be. So I'm not going to spend time on it, but it's a context of the issue is a context of bankruptcy and whether a lease is characterized as a deposit rather is characterized as a security interest, in which case you're into some of the bankruptcy and priority issues, or prepaid rent, in which case you may have a situation of the unsecured landlord having to provide the money to a trustee in bankruptcy. And the last issue, just I think that I'll mention and that you should be aware of, is that the issue of limitations period as it relates to rent has been considered by the courts. Our general understanding, I would say at this point, is that if it's rent, the landlord can go back a period of 6 years under the Real Property Limitations Act, but a tenant can't do that. So that's also an area that's worth exploring. So those are my cases.
Do you have any questions?
Not at the moment, so we'll have a bit of a period for questions. Let's finish up.
Terrific. Thank you very much, Mr. Giesenfeld. Appreciate that. And last but not least, we are going to ask Stephen Posen to discuss landlord and tenant defaults.
Actually, the way this was advertised was remedies, and it's relevant for the following reasons. And I'm going to explain it by telling you a story. Harvey started with a story. I will almost end with a story. I was planning during my less pecunious years on taking a trip, on traveling, but I couldn't afford very much money. Travel agent said there was a very cheap trip available to go to Spain. I said, but I don't speak Spanish. So the agent said, just speak very slowly. So I got there on the first night that I was there, and I went to the bar, and I said to the bartender, may I please have a scotch and soda? The bartender brought him a scotch and soda, and as bartenders are wont to do, he hung around, and they started to chat, and the bartender said, where are you from? And I said, I am from Newfoundland. And the bartender said, that is strange. I also am from Newfoundland. And then I thought about that for a minute, and then I said, I don't understand. If you are from Newfoundland and I am from Newfoundland, why are we both speaking Spanish? Now, it's problematic to tell a joke when there's no audience. Why is that relevant? Because it's not exactly relevant, but gentlemen, I'm doing remedies. That's the way it's advertised. Harvey starts off talking about remedies. Earl then supposed to talk about distress. He talks about a whole range of remedies. The only guy who stayed his proper course was Sheldon. So just from now on, stick to the script. Number two, I want to make a couple of other points. Harvey made the point earlier, which is not exactly in my sphere, but he said even a single arbitrator is expensive to run an arbitration of a renewal rent when there's not a lot at issue. I have an issue with saying there's not a lot at issue and you should use a single arbitrator. I know, Harvey, you're doing arbitration, but I have concluded long ago that even a single arbitrator is way too expensive to determine rent renewal for a small space or where there's a small amount at issue. And Harvey said that there was that you'd be 30 or 40, I forget what number, $50,000 before you open the door. I think it's impossible to do a full-blown arbitration for less on both sides than $100,000 and probably much more than that between expert witnesses, lawyers, arbitrator, and the like. Therefore, what's my solution and my suggestion is that all renewal rent, unless there's a lot at issue, should be determined by a single independent expert appointed by the parties. And if they don't agree, let the court appoint the expert as though it was going to be a single arbitrator, let the expert do his thing and make the determination. So that's comment number one, just my suggestion. Number two, one of you talked about e-notices by emails or faxes, and I wanted to suggest that given the technology in the world today, I advise all of our clients not to do any notices by emails or faxes because of the fact that they are not reliable. As a matter of fact, I just this morning had released from my spam filter a request from a client of ours last Thursday to deal with something by tomorrow. And it just came out of our spam filter today, and I'm lucky I got it out of the spam filter. Emails and faxes are not relevant, not the proper way. It should be either personal delivery or registered mail, which takes a few days longer. That's my advice. And the last introductory comment I want to make is that Sheldon said, and I disagree with him about this, that some of the decisions in the BC courts were quirky. I don't agree with that. I think that many of the decisions in the BC courts are not quirky, but incorrect in law. And so, judges, I apologize if I seem disrespectful, but if Donald Trump isn't being charged with contempt of court, neither should I. So having said all of that, and without any knowledge of how much time I have to go, I'm allowed, and recognizing that I don't really speak fluent Spanish, I do want to say that I have lectured on tenant defaults and landlord remedies on a number of occasions. And I've been given anywhere between 12 minutes once by the Law Society and an hour by other organizations. And it's very difficult to give the same lecture between 12 minutes and an hour. So I've decided to do this in Spanish, and however much I cover, that's how much I cover. So is my time up? Okay. So tenant defaults, and I will retread a little bit of ground because there are two types of defaults. One is monetary default and one is a non-monetary default. But let me distinguish between monetary defaults, between rent and non-rent. And Sheldon already touched this issue. It's preferable that all monetary amounts payable under a lease be called rent. And the reason why it's preferable is because there are better remedies available for it. You don't, Earl, I differ with you from this. You said you get to distrain for monetary defaults. That's not correct. I think you didn't mean it exactly that. What you get to distrain for is arrears of rent. So that's one remedy that's preferred. That's better to call all monetary amounts to be calling them rent. And what are items? There's basic rent, but there's also percentage rent. There's operating costs and taxes, which are additional rent. Utilities were additional rent. Even some amounts which are payable to third parties could be utilities, could be called rent. And so it's better because A, you get to distrain, B, you have a better limitation period, maybe. And the limitation period issue is an interesting one because in Ontario, you judges know this better probably than we do, but there is the Limitations Act where the limitation period to collect on an amount owing is 2 years. And there's the Real Property Limitations Act where the right to collect on arrears of rent is 6 years. And so the question is whether or not, a question on this point is whether or not amounts that are additional rent, like contributions by tenants on account of operating costs or realty taxes, whether they are or are not rent. And there is a case that did hold, and I forget the name of it, Pickering maybe and Trillium. But anyway, the case that did hold that if the payment is regular and of the nature of rent, like an operating cost which is payable monthly, it can be called rent, and therefore there is a 6-year limitation period. But it is an issue, and so another reason why items that are not basic rent should also be called rent. The other thing is that it's a little more easy to terminate for arrears of rent than it is for non-monetary defaults, and we'll deal with that separately. Another benefit of calling a monetary default rent is that on bankruptcy, in the event of a bankruptcy, and as long as the lease provides for it, which all leases currently do, excuse me, that the landlord is entitled to accelerate rent or has a preferred claim for accelerated rent, both 3 months forward and 3 months backward. And that's what that is the way in which the lease should be expressing itself. That's another reason why the determination of monetary amounts should be dealt with as rent. A properly drawn lease, I would suggest, should also allow a landlord to accelerate rent in the event of a default, irrespective of whether or not there's a bankruptcy. So if a tenant is in default under in rent, the landlord might say, I am hereby accelerating the rent. Then we turn over it. So you've now got, we're not 1 month arrears, but now you've got 4 months of arrears. Then you turn to Earl and say, work your magic. We've got 4 months of arrears. And so that's another benefit of calling it, calling a monetary amount to be equivalent of rent. A non-monetary default is a little bit more difficult. It's a little more difficult to deal with. What are examples of non-monetary defaults? Excuse me. I made a note to Sheldon a little earlier when Harvey was speaking. Does he want some vodka? This is my vodka. It's actually water, sirs and ladies. What are some non-monetary defaults? Retail leases generally provide, if they're properly drawn, that a tenant must actively conduct business on the premises throughout the entire term of the lease, during all business hours. If a tenant does not do that, what is a landlord's remedy for that? So first off, I do want to say that one would have thought in earlier years before the courts straightened this out, or depending on your view about it, because this was not a BC court, but in the view of some of us, the courts messed it up. That in the common law provinces of Canada, it is virtually impossible to get an injunction to require a tenant to stay open for the conduct of business, which is a real problem for a landlord, because if the tenant is not conducting business in a shopping center, and that can lead to a domino effect of other tenants not conducting business, it can destroy the value of a shopping center. So an injunction really would be a desirable remedy to have available. But like I said, in the common law provinces of Canada, it's not really available except potentially for a very major tenant, and even then, probably not. So disturbing conduct or noise, failure to repair, those are all examples of non-monetary defaults. So in order to exercise your rights as a landlord for a non-monetary default, it's pretty much only one of two possibilities. Number one is you can terminate, but you have to go through a different notice of termination, because you have to give, irrespective of what the lease says, you have to give notice for a breach of non-monetary default. And you also have to say something rather strange under the Commercial Tenancies Act. You have to say that in the notice that the landlord is demanding compensation for the breach. I have no idea what compensation for the breach even means, because if you're not repairing, or if you're not operating and the like, I don't know what the compensation should look like. But we simply put in a fictional amount, and ask for it. So, but the point is that the best way to deal with a non-monetary default is for a landlord, unless it's not operating the business, but a failure to repair is the best example. For a landlord to go in under the lease, it should provide that the landlord can remedy any default, and that the landlord can then say the amount that I incur in the cost of remedying your default becomes rent, and then I've got the old circle of remedies available for a landlord for a default in payment of rent. Now, what are the remedies that are available for a landlord for termination, for a default in payments of rent? And by the way, it was done as a slide, but we're not putting it up as a slide because I think that would obstruct my beautiful physiognomy. Is that a fair statement? So there.
But it is available They can actually open it themselves.
Okay, so you've got a slide, which is a decision tree, which actually contains everything that you want to have in one piece of paper. And then when you don't understand the language, call, Harvey's no longer in private practice, so call Sheldon or me, and we'll be happy to help you out. So typically what happens, you've got a non-payment, you've got a default in the payment of rent, and then we go through with our clients the same exercise that Earl described a little bit earlier, which is, what do you want to achieve? Because you cannot both distrain and terminate if those are the two things if those are the two primary choices that you have. You can't distrain and terminate at the same time, because why? Because a right of distress is the right of a landlord to distrain against the tenant's chattels and hold them as security, and then 5 days later get them appraised under oath and sold and apply the proceeds on account of the arrears of rent. But if there's no lease, there's no right of a landlord, because there's no landlord-tenant relationship anymore. Therefore, people used to go in and lock up the premises and secure them and then go and sell the goods for under distress. You can't do that because those two remedies are mutually exclusive. So the first thing to figure out is, what is your primary objective? Is it to terminate and get the premises back because it may be that you can make better use of the space? Is it to try to recover the arrears from the tenant? If you distrain and use that remedy for trying to recover the arrears, you may thereby, depending on the nature of the tenancy, put the tenant out of business anyway. So that may be the best thing you can do is to distrain, get what you can out of it, and then follow later your opportunity to terminate. What else might you do? You might also seek a declaratory judgment that you're entitled to certain money. Earl saved for me one story that we share, where we really, all we wanted to do was, as a landlord, was to collect the money from a defaulting tenant. But it was a major tenant that's a major tenant in the retail world today, and there was no chance that there was going to be any prospect of the tenant going into bankruptcy. The question was, how do we get our money? So the tenant sold. It was a sort of a department store. You could probably figure out from what I'm saying who the tenant was, but it was a fairly large department store that sold, in the appropriate season, sold barbecues. So Earl and I decided what we would do is, just in advance of Father's Day, listen, I didn't interrupt yours. I'm not just kidding. Yes, it was Father's Day. Yeah, Earl's right. It was Father's Day. So just before Father's Day, Earl and I agreed that Earl would go in and distrain on all of the barbecues that this tenant had for sale. But Earl said he usually goes in and just simply tags them, and that's called a constructive distress. But the right of the landlord is actually to take possession of the goods which are being distrained. So in this particular case, what we did, I didn't do it, Earl did it. What we did was we took all the barbecues and put them in storage elsewhere on the same shopping center, but just in advance of Father's Day. We got paid. And so there was a fight about whether or not the money was payable, but we got our money, and it's always better to argue when the money's in your hands than it's not. After distress, after distress, if there is a shortfall, the question is, what can you do as a result of that shortfall? Can you then terminate the lease? Earl said correctly, you need to then do a new notice of default. But I think that the case law is now relatively clear that you actually need a new default. You can't terminate for an old default that you've already distrained on. You have to have a new default. Now, there's ways of getting it. Even if the tenant continues to pay rent, you can apply the rent on account of the old rent and leave the new rent in default and then do a new default notice that way. But if there's a shortfall following a distress, you must take other steps. So I know you folks are judges, and I know you believe in the value of the courts. I used to be a litigator, and I do not believe so much in the value of the courts. Sometimes we don't have choices, but sometimes we do. And so what I have sometimes done is I haven't followed the rules, shall I say. So an example of that was when I said you have to get a new default. Once we had a restaurateur that was in default, And I know you guys are tired of hearing the story, but to me, it was a really good story, a good solution to a bad problem. We had a restaurateur and a shopping center that was in default perpetually. We had Distrained, he paid, Distrained paid, Distrained paid. Finally, the landlord said, I'm finished, get rid of him. Well, Earl was talking about what do you do in a restaurant when you go to sell goods, they're worth pennies on the dollar. The landlord is not allowed to sell under distress to himself or herself, unless be sold to a third party. That's the rule. And by the way, the leases should be drafted so you do get the right to buy it from yourself, as long as you pay for the proper price. So what we did in that case was we arranged in advance the following. We arranged when the distress is going to be held, we arranged with a friendly third party kitchen supplier to buy all the goods at the distressed value. Then that kitchen supplier was then going to, by pre-arrangement, going to sell it to a new tenant at a profit to that kitchen supplier, so he was happy to cooperate. We arranged for a new tenant, signed a lease, and delivered it, conditional on getting possession. We then, Harvey, it should have been vodka, not water. You'd be feeling better. So what we did was we distrained, and he was used to being distrained against and paying off as time went by. We went in a week later with the bailiff, a couple of appraisers, the new tenant, and the kitchen supplier. The appraisers swore the affidavits of value, which we knew in advance were going to be about $35,000. We sold the goods to the kitchen supplier for $40,000, so that there would be no allegation we sold under value. We then turned to the tenant and said, okay, you're still in default for another $75,000 or whatever the numbers were. So you know what? We hereby terminating, handed them termination notice, and escorted and then turned the lease over to the new tenant. The new tenant gave a check to the bailiff, to the kitchen supplier to buy the goods for pennies on the dollar. Like it was a $400,000 or $300,000 kitchen and restaurant with tables and chairs. Bought the whole thing for a bargain of $40,000. Everybody was happy, or $45,000. The kitchen supplier was happy. The new tenant was happy. The landlord was happy. The former tenant really didn't look that happy, and he was escorted off the premises. How do you terminate a lease? Sorry, Sheldon.
Would you still do that today?
Maybe. I think it depends on who the parties are. If I felt honestly that the tenant would not get sophisticated legal advice because he couldn't afford it, I probably would take a chance on doing it. But it was wrong because I didn't give a new default notice. I didn't even have a new default. How do you terminate a lease? You don't terminate a lease, as some people think, and I don't know what you folks think. You don't terminate a lease by saying the lease is hereby terminated. That is not a termination of the lease. The only ways to terminate the lease are either 1, to physically take possession of the premises, 2, get a court order, I may have to consult my decision tree because I think my recollections, there's 3 ways of doing it. You can get a court order and an action, or you can get a court order under Part 3 of the Commercial Tenancies Act to get an order that the lease has been terminated. And then the sheriff will come riding in on his horse and enforce that order. So the only way you can terminate a lease is in that manner. So what should you do if there's a default and you want to get rid of it, you want to terminate the lease so you can make better use of the premises, but you don't have a new tenant yet? It may be desirable for both the landlord and the tenant, defaulting tenant, for the tenancy to continue at least for a short period of time while a new tenant is found and while the former tenant can do business and make a little bit of money in the premises pending the new tenant arriving. So another way of proceeding would be to have the lease terminated and have the old tenant sign an agreement admitting or acknowledging the lease has been terminated and that he remains on in possession as a monthly tenant or tenant at will. So I don't know what my timing is, but I have a feeling that I'm running into difficulty. I have 2 minutes. Okay, so there's another element that maybe you folks would like to consider or be aware of, and that's this. If a landlord, the leases all provide that a non-waiver clause, which provide that if you've waived a default, it's not a valid waiver unless it's in writing. So the point is this: that if notwithstanding those waiver clauses, if you as a landlord accept rent following the default in payment of rent and a notice of default, setting yourself up to terminate, and you then accept the next month's rent, you have waived the default in respect of which you serve the notice of default in the first place. So you're going to need to have a whole new setup to be able to terminate. And again, you need new arrears of rent. So if you receive rent afterwards, you can apply it on account of the old rent, then the new rent is in default and you would start that way. So if you accept rent after having served a notice of default as a landlord, the case law is such now that, in my view, and I hope Harvey and Sheldon would agree with this, is that the landlord will have waived his right to terminate based on that default. So do you want me to continue on? Because I
Unless you've got a short point to make.
I should talk a little bit about, because this was also advertised as tenants' remedies for landlord defaults. And my favorite one about this is landlord having withheld consent to an assignment of a lease. And the BC courts, heaven love them, held, but problematically the rest of the country's courts have followed, that if a landlord is found later to have withheld consent incorrectly, and if as a result of that, the tenant lost a prospective sale of a business, the landlord could be held responsible 2 years later when some judge with no experience in the area solemnically determines that the landlord should have granted consent and the tenant lost the sale, and therefore the landlord has to pay the tenant for the loss of the value of the sale. I had a situation similar to that a couple of years ago where, it was clear. The proper leases, by the way, now should all provide that if the landlord withholds consent incorrectly, the tenant's only remedy is to get a court-ordered consent, which can be done on a summary application to the courts. And I actually don't know whether small claims court have jurisdiction on this, but I think not. I think it has to be Superior Court to get a court-ordered consent. Should be the tenant's only remedy. I had a situation where our lease did not contain that clause. Excuse me, and we got. And we got information that their financial situation following the sale would be a very flat or zero covenant because the tenant itself was giving security to the bank to finance its own purchase. So they went from a many $1 million covenant to a zero covenant. And the night before the closing was to occur and we were supposed to have granted our consent, I contacted the lawyer and said, we are not consenting. And if you wish to challenge that, I'm prepared to meet you in court tomorrow morning at 9 o'clock if you can get a judge to make a determination, and you can argue whether or not you think the landlord should have granted consent so as to try to forestall the tenant's future claim for some judge deciding 2 years later after a trial that we should have granted consent. The tenant in that case caved. The deal did not close. And the tenant in that case made me feel very good because he went into our client's office the next day and said that we were right to withhold consent. And with that, unless there's any questions, that's the end of my time. And I thank you very much for your attention.
Okay, I believe we do have some questions.
No, the phone one.
Oh, far one over.
Okay, we have 3 questions online. The first one is from Brian Murata. In residential tenancies for damages, rent arrears, and utilities, does the Landlord and Tenant Board or Small Claims Court have jurisdiction?
So I don't know if you can hear me well enough or not, and I hope somebody else here can answer the question. I have judges that directed at me because I was dealing with remedies. This entire talk was based on strictly commercial tenancies, not residential, and I'm not prepared to give an answer on residential tenancies because I know a little but not enough about it. Do you know the answer?
No, same thing. My gut would tell me it would be the landlord tenant
me too.
board.
The board, me too.
But we don't have any experience.
That's the advantage of giving free advice is that we're not responsible.
There you are.
Okay, the next question, of course, along the lines of the above, perhaps the presenters could comment on the differences in the types of cases we might find as deputy judges in both residential and commercial leases, obviously, because residential leases are much more restrictive.
Okay, well, I'll take a shot at
I'll let Earl answer that.
Unfortunately, the reality is that those of us sitting at this table here do not deal with residential tenancies. In commercial tenancies, we have contractual remedies, some are common law, right, remedies. And a lot of it's fairly clear. Much of what I talked about was just interpretation. And Steve, if you look at the decision tree that he's given you, that really is everything you need to know about commercial tenancies. In terms of residential tenancies, I think it always is a matter of what the board decides. So I think for all those issues, all residential tenancies issues, you would have to go to the board. And generally speaking, and this is, I maybe shouldn't be saying it, but generally speaking, the Residential Tenancies Commission or Landlord Tenant Board, whatever it's called today, will be leaning over backwards to assist a tenant. And it's very, very difficult. I would suspect that by the time a residential tenancy matter comes to the court, it's been around the bend many times.
So I just want to add one thing to that. As without knowledge, I'm going to guess that any uncontested amounts that are owed by a former tenant to a landlord whose tenancy has been completed, but there are arrears of rent, I'm going to guess that the small claims court has jurisdiction to order payment of those arrears.
I just want to add that as bailiffs here in Ontario, we are not allowed to do any work with regard to residential tenancies. So 100% of what we do is by statute and under the Commercial Tenancies Act.
Any more questions?
Yes, we do have one last question, which is from Kenneth Hagan. If a tenant becomes a monthly tenant, is there any notice period to terminate the monthly tenancy, or does it just depend on what was agreed?
Yeah. The answer is that in a true monthly tenancy, the tenancy can be terminated on 1 month's notice, but that's not 1 calendar month, it's 1 clear month's notice. So for example, and it depends on the facts, but let's assume that there's a tenancy commencing on and rent payable on the first of every month. If you want to terminate on 1 month's notice, you have to terminate the notice has to be given prior to the beginning of the month in which the rent is payable. So for example, it's a monthly tenancy, and you want to terminate the lease at the end of June of this year, say, the notice has to be given prior to the end of May or by the end of May.
You missed it.
What?
You missed it for this year.
Yeah, yes. Yeah, so any of you are landlords on the side and you want to terminate this year, you're too late. Okay, that's Sheldon's contribution. Okay. And I think you should say it in Spanish. That's it. Okay.
Did you have another comment, Mr. Haber? I'll just wait. Am I clear, Edward? So thank you very much, everyone, for participating in today's panel discussion. Very entertaining. I can see why you all do this on a regular basis, because it's for money. There you go. Certainly appreciate you coming together today and making this presentation for the deputy judges. Certainly, in the deputy judges world, in small claims, they don't deal a lot in commercial leases, but when they do, it's nice to know that there are people out there who have that expertise and that they can certainly draw on your comments today. So thank you all very much for joining us today.